Hi, I'm Chris here at Punchwork, and today we're going to talk about retaliation. Retaliation happens in workplaces across this country. It's important to know your rights. Let's get into it. So retaliation is protected under a federal law called Title VII, Title VII in Latin numerals. That means that speaking up is protected. If, for example, you speak up in the workplace and say, it's unfair that I, as a woman, are being treated differently, or I'm being treated differently on the basis of my race or skin color, if you speak up, that's protected. And what exactly was protected has always been a debate about. There's always lawsuits and cases, and there was a little bit of confusion about what retaliation meant under Title VII for a long time. And so some courts said that to be retaliated against meant you had to be fired, or you had to lose a significant amount of your pay. That's what some courts thought retaliation meant under Title VII for a long time. Other cases had broader protection. If you were transferred because you spoke up or some other action happened to you, courts said that was illegal retaliation too. So there wasn't exactly a clear standard for Title VII retaliation for a long time, but that changed, and we'll get more into that. So a big case came along that cleared up what retaliation meant under Title VII, under the federal law that protects against discrimination. This case, I call it Burlington Northern v. White. It set the standard back in 2006. And to start to talk about what happened in that case, Sheila White, and she was the only woman in her position, and she reported harassment of her supervisor. And it's something that you don't have to report harassment for it to be illegal, but she did in this case. And initially, her supervisor was disciplined for what was happening to her. So initially, that was good news for Sheila. So in this Burlington Northern case, Sheila was initially okay. But after her supervisor got suspended, she herself got transferred to a harder job. And then she got suspended for 37 days without pay. It wasn't a suspension where she got a paycheck. So she knew her rights. She stood up for herself. She filed a retaliation claim for her suspension. So here is the issue with Sheila's complaint against Burlington Northern. We talked earlier about how the law had been confusing for a period of time. So the question in Sheila's case was, she wasn't fired. She didn't have permanent pay loss. She was only suspended for 37 days without pay. Did that count as retaliation as a matter of law under Title VII, under the law of the land from the United States Supreme Court? And what the United States Supreme Court ended up saying in this case of White v. Burlington Northern is it wanted to look at a reasonable worker standard. Would the adverse action, in this instance, the suspension without pay, would that discourage a reasonable worker from speaking up? Because that's the point of an anti-retaliation provision, to encourage people to report illegal activity. And so what the court said is retaliation under Title VII is not just a firing. It can be a suspension too. That's really what the Burlington Northern case stands for, is that the definition of a retaliatory adverse action under Title VII is broader just than a firing or a demotion. So the Burlington Northern case, it says that reassignment, suspension, worse conditions, all of those things can be retaliation under the law. The loss of opportunity, like if you were shifted to another position and therefore you couldn't be promoted, or prestige, all of those things materially impact a reasonable worker. And if they happen to a reasonable worker, they would discourage them from speaking out under the law. And so that contrasts with just a petty slight, minor workplace wording, a little bit of a different attitude. You know, federal courts aren't going to mandate that your supervisor have a great attitude with you. I mean, that would be a perfect world, right? But those things are not actionable retaliation claims, you know, petty slight. But what is actionable is transfer, reassignment, worse conditions, all of those things. The law is clear now. A company can't do that to you for speaking out for your rights under Title VII. So here's the bottom line about this Burlington Northern case. At the end of the day, as the employee, you're protected from retaliation. And a lot of people don't know that. A lot of people feel powerless. They don't know their rights. Bottom line is you're protected. And it's not just from being treated differently on the basis of your age, your gender, or race, your national origin, your skin color. It's also for standing against retaliation. And people say, well, Chris, that's all well and good. You're a lawyer talking about the law, drawn on these whiteboards. But what about me who actually fears for my job? And what I say to people is, retaliation is more expensive for the company to pay out. If a company has an ordinary claim of discrimination, that's one thing, but to have a retaliation claim on top of that, if you win, that's going to be a lot more expensive for the company to deal with. And so they take retaliation a lot more seriously than they do what I call ordinary discrimination claims. So because of that, because it's going to cost the company a lot more if they retaliate, that's why I have a lot of confidence to say you're protected from retaliation under the law. It's important to know your rights and act on them.